Welcome to our Learn Community Education webinar. I'm JP Benlian. I'm with Oasis Senior Advisors. And today our topic is navigating the Medicare appeals process with Melissa Allen. Learn, it stands for Lifelong Education and Aging Resource Network, is an Idaho-based nonprofit providing community education on aging and caregiving topics. Learn is part of the Society of Certified Senior Advisors Leaders Network. Again, the content provided here is for general information only and not to be considered legal, financial, or health advice. Today, our sponsors are Peggy Farnworth CPA and the Counseling Center. And again, we've got Melissa Allen presenting this information this afternoon. Melissa was born and raised in Fairbanks, Alaska. After a move to Florida to be with her husband, Melissa worked in Medicare for just under 5 years in appeals compliance. Melissa left Medicare to finish her law degree and graduated this past May from the University of Idaho College of Law. Melissa was recently admitted to the Idaho State Bar and has been practicing at McCool Law, working in probate, estate planning, guardianship, and elder abuse. Being a true Alaskan, Melissa loves to be outside in the winter, enjoying snowshoeing and cross-country skiing. Melissa also has 3 dogs and a horse to keep her busy in the free time. All right, with that, Melissa, let's go ahead and let you present the content.
Well, thank you for that introduction. Let me see if I can share my screen. And share. We should. Are you seeing just the slideshow?
I am.
Perfect. And I have the subtitles on just to help. I know they're not perfect, but sometimes they're nice to have on.
Absolutely.
So as we talked about, I will be discussing how to navigate the Medicare appeals process. For a lot of people, it can be very confusing. So first, we'll start with what is Medicare. So there's Medicare Part A, Part B, and Part D, which is part of what's called traditional Medicare. Part A takes care of inpatient expenses like a hospital stay or any other facility stay. Part B covers your outpatient visits, including like doctors, therapists, that other thing that you would see not in a hospital setting necessarily. And Part D covers your prescription drug costs. A lot of what I'm going to talk about today is dealing with a Medicare Advantage plan. The rules are identical for Medicare. It's just a little bit easier with Medicare as you're dealing directly with Medicare when you're appealing with them. So what is a Medicare Advantage plan? Medicare Advantage plans combine Part A and Part B to form what's called Part C. Part C is regulated by Medicare and overseen by the CMS. And they perform what's called audits on all Medicare Advantage plans to ensure compliance, but those happen once every 3 years. The advantage of the Advantage plan is that it includes additional coverage like dental, behavioral health, and other drugs not covered by Part D, and generally is accepted by an expanded network of doctors, which may open access to other providers who you may not have access to just generally on the Medicare network. It can also have a lower cost to members for certain services, And then there's most recently Medicare, Medicaid plans called dual special needs plans. And they are also part of the Medicare Advantage in some instances. So a lot of what we're going to talk about today is going to start with what's called pre-service and post-service appeals. I'm going to start with the pre-service side because this is the most critical time. This is when you haven't received a service yet, but plan on receiving something. Post-service will deal with after you've been to the doctor or the hospital and you've submitted a claim and your claim has been denied. So we'll start with what is a prior authorization. I think most of us should be familiar with this. This has become a very popular tool for insurance companies to gatekeep access to care. So it's a request made by someone before services are rendered. So if you need imaging or a surgery or durable medical equipment, this may be utilized by your insurance company. Medicare often does it as well. You may also hear them referred to as organization determinations. That is just a fancy way to say prior authorization, and it's the first level to gain access to care. So if you are asking for a Part D or Part B drug, a Part B drug is a drug that's administered through like a syringe or IV, and it's not included underneath Part D. The requests for those are done in 24 hours. And if it's expedited, meaning this person needs it to save their life, I'll go into what expedited means in greater detail a little bit later. But the standard request just for any other drug can take up to 3 days, or 72 hours. All other authorizations for like doctor's visits, surgeries can be done within 72 hours for expedited and extended up to 14 days, or for the standard time frame be 14 days and then expanded the additional 14 days. I'll talk a little bit about the expansions later because the same rule applies for prior authorizations and appeals. So who can request a prior authorization? Normally it's done by doctors or providers. So it'll be the doctor that you see in your office. If you need a prosthetic or other durable medical equipment, it may be that provider, whoever's making it. If you're receiving home health, it may come from the home health providers, or it may come from a nurse practitioner or whoever else you might see. You can also request a prior authorization for a service, but generally you have to submit documentation to support your request, and the provider is generally the best resource for it. A lot of providers are pretty comfortable with requesting prior authorizations because this determines whether or not they're going to be paid. So it's pretty standard now to even see prior authorization departments in clinics, hospitals, even into like your local practices. So what is a denial? This is where we start getting into the appeal area. Denials can come in a lot of different forms. It may be a phone call to you or to your provider telling you that a service has been denied. It may be what's called a notice of Medicare non-coverage or a NOMNIC. You'll hear that term kind of frequently. You know, the government loves acronyms. So a lot of times this may be what's said to you when this information is being relayed to you. So I think it's just helpful to hear how somebody might say it to you. You might also get a notice of denial of medical coverage or an NDMC. You might also receive what's called a level of care denial or a LOC. Or for traditional Medicare, you'll receive a Medicare summary notice or an MSN. A verbal denial will always be followed by a written denial, but in some certain circumstances, they're required to give you verbal notice because the denial of the service may jeopardize the life of the member. So they have to give a phone call to let you know that it's been denied and give you the chance to appeal at that time. The notice of Medicare non-coverage is only seen in certain circumstances, which I'll talk about later. But most commonly, what you'll see is the notice of denial of medical coverage, or the NDMC. All of these forms must have the information on them. The level of care denial is the only denial that doesn't give an appeal rights. The level of care isn't actually a denial of a service that you are receiving. It's denial of the level of the care of the service that you're receiving. And level of care denials must always be done as a post-service appeal. So you have to submit the claim and then appeal the claim denial if it occurs. Those are more courtesy notices that tell the doctors that they either need to step up their documentation of what services and why you need them in the hospital setting. But generally, those will never include any sort of appeal information, and that's how you can kind of tell that it's not something that's an actual denial of what you're receiving. I know that's a lot of information here. We'll go into some of these a little bit further later on. So a lot of people, one of the hardest things is how do you appeal? So Medicare is part of the federal government, and because it's part of the federal government and administered by the Centers for Medicare and Medicaid, it is subject to what are called administrative rules. And this process is absolutely critical. I can't stress that. You must follow what they tell you in order for you to be successful or to be able to challenge it legally. So on your denials, you're given a set of rights. And so you must follow what those rights say. It should give you the time frame that you have to appeal. It will give you the methods in which you may appeal. It should give your authorization number and why it's being denied. If there is none of this information or information that's confusing or lacking, you can file a complaint. There have been a series of findings, especially on the recent Medicare audits, that the letters to members are insufficient, including incorrect appeal information, incorrect timeframes, and incorrect denial reasons. So all of those issues are a reason for you to either get your appeal approved or have the insurance company fined. So it's very important that you follow those directions. Again, on your notice, you're going to have a time frame. So for the appeals for drugs, it will tell you the standard time frame being 24 to 72 hours, the standard time frame being up to 7 days. For other service, it's 30 days for standard, and then 72 hours for expedited. And this really means exactly 72 hours down to the minute. The company, including Medicare or any provider of an Advantage plan, must document the exact minute that your appeal was received, because that determines the exact minute that your appeal is due. There's something called the peer-to-peer timeframe, which is a kind of pre-denial period where your provider may be given the chance to speak with the doctor who is reviewing the prior authorization. That's not a denial period, and you can't appeal during that time frame because the doctor may speak to the physician reviewing the prior authorization and convince them to actually approve the prior authorization. So if there is a peer-to-peer timeframe, it's very important to talk with your doctor and either ask them to do the peer-to-peer or ask them to decline the peer-to-peer so that it may be denied, and then you can move forward with the appeal process. Some doctors, especially in the hospital situation, may rather opt to decline the peer-to-peer, especially if they're a rotating doctor. But it's very important to have this communication with them. A lot of the times the insurance company is generally talking directly to the doctor. So if you know or are waiting on a prior authorization, it's always helpful to communicate with them on the status of what's going on in your case. Extensions may be granted when there's a prior authorization review and not enough documentation is there for the company to make a decision. And it's the same for an appeal. If you've submitted an appeal on a service, the insurance company can ask you, or Medicare can ask you, for a 14-day extension of your appeal so that they may receive documents. This is always a tricky thing because most people would think that, oh, more time means I can submit more things and the decision may be more favorable. But the truth is that these companies have to decide within that time frame whether or not they can justify denying you that service. If they can't justify denying you that service, they're going to approve it because when they do what's called an uphold of the denial, they have to prove to Medicare or to an independent review organization that it's true. And if they're wrong, if their denial isn't justified, they can be fined. They can actually lose millions of dollars if they do it frequently enough. So it's really in your best interest to not ask for an extension unless it's absolutely needed. So now we've talked about the timeframes to appeal when you have appealed, but you have between 30 and 60 days to submit your appeal. Generally, it's always going to be 60 days. There's some instances where 30 days are needed to appeal by because of certification issues. But so 60 days is generally the rule. And just because you miss that 60 days doesn't mean that you can't appeal. You just have to show that there was good cause for you not to appeal. So what is good cause? Good cause can be anything from your mail was not delivered correctly, you were given wrong information about the appeal, you thought that somebody else was appealing on your behalf, or for any other reason that you might think like you were going to try a different service or try something else. Anything like that can be considered good cause, but you must state that when you're appealing. So I've talked to you a little bit about expedited and standard timeframes. So what is expedited? Expedited means that if the person is denied this service, there is a chance that it's going to jeopardize their health or their ability to recover. So when we're talking about that, you might think something like cancer treatments, because those are very time sensitive, and cardiac issues, admissions to hospitals, acute inpatient rehabs, and other rehab centers, physical therapy, occupational therapy, other therapies that if they're not done within the next 30 days, that it's going to cause potential detriment to the person receiving the services. If your provider indicates that this 30-day timeframe will jeopardize your health or ability to recover, it must be done as expedited by the plan. This is a must rule, and that's the exact regulation for that. A lot of the times, what we've seen, especially in whistleblower complaints, is that companies are getting around this requirement by trying to talk to the doctor about it or saying that they've upgraded it to expedited. So if you make it very clear to begin with, there's no way to get around it, right? It shouldn't be that way, but it is. And that's the unfortunate truth. So knowing, what this service means to you, knowing what it means for your recovery, can help you be a better advocate for yourself and help you get your appeal in the time frame that you need. So who can appeal? The member is the person who holds the key to the appeal. Every single denial you will ever receive can always be appealed by yourself. You can also nominate someone else to do it for you, or your doctor or whoever is required, who's asked for the service, can appeal for you as well. To talk more about the member, since this is your choice, like your service is directly tied to your medical preference and what you want, your voice is really powerful in this matter, and really the only one that Medicare or Medicare Advantage plan wants to hear from. Doctors generally appeal for patients that they know, but won't for patients that they don't, or patients that they're just doing rounds on. And it can be really hard to get assistance from them, especially in scenarios where it may not be your regular doctor. Other doctors, if it's your regular doctor, are generally pretty on top of this process and will appeal for you, but it's important to have that conversation. You both can appeal as well at the same time, but generally those will be combined into one appeal case. Having support from a provider is always helpful, as they will provide information to the insurance and help strengthen your case. If you do decide that you would rather have somebody appeal for you, know that you must submit paperwork that shows that this person has the right to. It can't be verbal, and it must be a legally sufficient paperwork. This can delay your case. The company is required to ask for paperwork, and it can delay your case up to 17 days. So I know a lot of people who are attending this may either may not be on Medicare, but might have somebody who is. If you want to be a representative for somebody, or somebody's asking to be a representative for them, submit your legal paperwork with your appeal. A lot of what we would see is a durable power of attorney or a medical power of attorney. Both are sufficient for the Medicare appeals process. What you should know, though, is that with a lot of medical powers of attorneys, you might see something about incapacity being a requirement before you can utilize that power. And the same with the durable power of attorney. A lot of people have it set up to where you must be incapacitated before you can exercise those powers. And if that's the case, you would need to submit a letter showing that from a doctor showing that the member is incapacitated. If it's one of those valid immediately, then you can go ahead and submit that and not expect any delays. Another way to, or another paperwork that's provided by Medicare is what's called an authorization of representation form, or AOR. Your Medicare Advantage plan will send it to you if you don't already have one, or you can access it at cms.gov at any time. I recommend, if you have a parent or a loved one who is on Medicare, to have this discussion with them about what they want to do if they are denied a service and they can't appeal for themselves, or if they would like someone to be able to appeal for them. I know a lot of people are already on their parents' accounts as somebody they can talk, but that's not sufficient for the appeal process. So filling out an AOR ahead of time is really helpful, because it doesn't give you any other power other than just the power to appeal on behalf of your loved one or the member. If you're a guardian, you could submit your guardianship paperwork and have that on file, and that would be sufficient. If you don't have anything on file and it turns out that your parent, loved one, or member hasn't signed anything, hasn't done any paperwork, and now they're incompetent, your only option may be a guardianship or asking a provider to appeal to get the services. A lot of the times we would see this be a really painful area for people because their loved one is experiencing something significant and requiring really big services, and they are unconscious or unable to talk or incoherent, and they're being denied services. So it's already a very frustrating situation. And if there's no documentation on file, there's no way that they can sign anything. The only option is either a provider or emergency guardianship. And in both those situations, you can experience these delays, right? So it's really important, especially for those who either are on Medicare or have loved ones on Medicare, to have this conversation ahead of time so that you can avoid this. So besides just the regular appeal process, I mentioned earlier the NOMNICs, or Notice of Medicare Non-Coverage. These are only issued in 4 situations, and that's if you're in a skilled nursing facility, utilizing comprehensive outpatient rehab facilities, on hospice, or currently receiving services from a home health care agency. Medicare considers these services incredibly important to members, and that the cessation of care can detrimentally harm members. So there's what's called a special appeals process through organizations that are called BFCC QIOs. That's Beneficiary Family Centered Care Quality Improvement Organization. You'll never hear that entire term. You'll almost always hear a QIO, or a Quality Improvement Organization. There are 2, and it's going to be KeyPro and Levanta. And KeyPro and Levanta have chopped up the states. You go to their website and figure out which state it is. For Idaho, it's KeyPro. And what happens is, when you're issued this Notice of Medicare Non-Coverage, or NOMNIC, you get what's called a last covered day. And up to noon the day before the last covered day, you can appeal with the quality improvement organization. You will get this notice a few days in advance of this last covered day so that you have time. If they don't give you this notice within that correct time frame and you don't have time to appeal the QIO, the notice is not valid, and you can call the QIO, file your appeal, and they'll tell them to do it again. So you can extend your time that way. It's an extremely rigid process, and if the notice is not correct, it's not valid. But it is important that you appeal with either the QIO or the insurance organization that you're dealing with to address that matter. If you appeal with the QIO, that is done within 24 hours, and they decide whether or not they can extend your stay, or if whether you're going to end coverage and be discharged from those services. If you miss the QIO timeframe, you still have time to appeal with your insurance organization, and you can call either Medicare or your Medicare Advantage plan to file your appeal, and they'll get the notice of Medicare non-coverage and decide whether or not you're allowed to stay. One of the most common areas is that skilled nursing facilities have a 120-day rule. So if you run up against that 120 days in the facility, you may actually be issued a different notice, and that's the only time that you may receive a different notice. Again, it's really important to read the notices that are given to you and understand where they're telling you to appeal. I'm giving you a lot of information now, but those notices will always guide you in what you should do. If they're wrong, it is always important to complain about it. That's the only way that these things get fixed, and it can also help you win your appeal. So I've talked a little bit about pre-service issues. Now we're going to talk about post-service issues. Post-service is really quite simple in the fact that you've already received the service, and so there's no risk to your health at this time. It's only a risk to your bank account, which is still very important, but it's something that has less dire consequences for your health. You can never expedite a post-service appeal. You've received the service. There's no way that it's going to be life-threatening to you. So it's always going to be on a standard 60-day time frame. They get 60 days to look at the service you received, any medical records that you've given, and decide whether or not it is covered. So you also have like a 14-day time period for prescription drugs. This is your Part D coverage and not your Part B drugs that you may receive in your doctor's office. So what if your appeal is denied? These rules are the same for pre-service and post-service. So let's say you've appealed, you've been denied by your insurance company or Medicare. What happens? You'll get a notice, and it'll be an uphold notice, and it will tell you that you can appeal to the independent review entity, which in most places is called Maximus. I've yet to encounter a state where it's not Maximus, but I know that there's a few other out there that exist. Some appeals are automatic, and they will automatically go to Maximus for review. Read your uphold notice to see whether or not yours was automatic, or if you need to appeal yourself to them. Maximus is really easy to deal with. You can just follow the information that's on your uphold notice to your local organization and start the appeal process with them. If your appeal is downgraded from expedited to a standard timeframe, you can file what's called an expedited grievance with the insurance organization. You'll still get a phone call and a letter from the insurance company about this downgrade. And then you can provide documentation as to why you need this service within the 24 hours. If you submit with a provider's letter justifying the expedited need, or the doctor says that you must have this within 30 days or your health is jeopardized, then it automatically goes back to expedited and it's due at the original time. This isn't a really common thing unless it's something that's been determined that you've already received the service, or that in your situation it isn't actually life-threatening or jeopardizing your health. But it's important to know your rights there. And anytime that this situation occurs, this grievance system is also tracked by Medicare. What also may occur is that your appeal might be dismissed. It can be dismissed for lack of legal documentation for your member representative that's appealing for you, or it could be dismissed for receiving services. And if you didn't actually receive the service, you can appeal to the independent review entity Maximus and ask them to reconsider, showing that you haven't had it. Or if you missed the deadline for the documentation for your representative, they can also appeal to the independent review entity and they can pick up from there. It is really important to appeal to Maximus if you've been denied, because you must exercise all of your appeal rights underneath the administrative rules before you can sue. So you may consult a lawyer. It was really common to see on the insurance side, lawyers would be sending letters threatening to sue if we didn't do this. And it doesn't mean anything because you must go through all the levels of the appeal before it can even be heard in court. Other than that, you could file, you could spend the money to do it, and then have it be immediately dismissed because you haven't exhausted all of your rights underneath these administrative rules. After the IRE organization, you would go to like an intermediary review after that. And then if you're denied there again, you would go to what's called an administrative law judge, where they would hear the case and either approve or deny it at there. And if it's denied there after that, you can finally appeal, you can finally sue in court. It's really important that you would do all of these steps, especially if it's something that is like a liver transplant or cancer treatments. I don't know if anyone's familiar with the Dexcom monitors for diabetics, but it actually became covered by Medicare because enough people took it all the way up to the administrative law judges for them to decide to change the policy for Medicare coverage to include the Dexcom monitors. This happened when I was still working for United Healthcare. It was like a December, January change where we had seen like 6 or 7 people go to the administrative law judge, appeal all the way. And Medicare finally decided that the language in Medicare should cover these. And they issued a ruling that said that Dexcom monitors would be covered. So it's really important, not even just for yourself, but if it's something like new technology that hasn't caught up with, or the insurance hasn't caught up with, that you exercise your right to do it. Usually, if the insurance denies you, the Maximus will pretty much overturn a lot of things from them. So insurance companies are really wary because if Maximus overturns them, they lose what are called star ratings, and that lowers their reimbursement from Medicare. So it should be something that is really rare if you file an appeal, unless it's something that's actually not warranted. Like I said, you should take it all the way up as far as you can to make sure that you are getting the service that you need, or having this maybe potentially changed by Medicare. So what happens if the insurance company or Medicare doesn't complete your appeal within the time frame? If you haven't had a request for additional paperwork, like from a member representative, or like if you haven't agreed to an extension, you're the person who knows when your appeal should be due. If you submitted an expedited appeal and you didn't get a downgrade to standard notice, you didn't get a phone call, 72 hours is when you should have it back. It's really important that you follow the exact letters on your denial notice. It has to have a phone number for you to appeal, a fax number to appeal, and an address for you to appeal to. If you've done those things, you know that this should be due on this day, and it doesn't happen, you should file a complaint with Medicare. I mean, even on Medicare, because these complaints are heard if it's from a Medicare Advantage plan by Medicare, or if it's Medicare, it's doing it, then an independent review entity like Maximus. So you should file a complaint. You are the only person that knows that your appeal is late. You are just one of hundreds of thousands of appeals every year that happens. And if you don't hold them accountable, they're not going to be accountable to anyone. One of the biggest things right now in audits is timeliness and companies not notifying members that they're late. If they are late in your appeal, in certain circumstances, the insurance has to stop doing what they're doing and send it on to the independent review entity to have them complete the appeal process, because they've lost the chance to do it themselves. Timeliness is a really important thing, and you're the only one who can sit there and say, look, I sent it in 4 days ago. I haven't heard anything. Nobody's told me that it's downgraded within that 72 hours. So my appeal is due now. Call Medicare, file a complaint, or go online and file a complaint and let them know that it hasn't been done on time. That's your right to have your appeal done within a time frame, and it's a violation of your right if it's not. This includes pre-service and post-service. If it's day 61 and you don't have anything, you should be filing a complaint with Medicare. Some people don't like to file complaints because they feel like, oh, well, it's not that big of a deal, but it is. It's a really big issue, and it's actually pervasive throughout insurance companies because people don't want to hold them accountable. This is one of the biggest issues on program audits, and it's hidden until it's found. And so many people are denied the care that's appropriate for them, and it may jeopardize their life with this delay. I mean, there were appeals that I saw that were for a cardiac procedure, and by the time the appeal was sent in or processed, the person was dead. This is common, it happens. And so you are the only person that knows when you sent it in. You should communicate the same thing to your family members, especially if it's a situation where you may lose the ability to communicate. It's very important to have that dialogue with the people around you so that they know what's going on. So I wanted to give some tips for appealing, since I would see a lot of errors or a lot of things, both from providers and members. If you're calling, give the exact information from your denial notice while you're on the phone. That's like your authorization number. And then also say what the service is as well. Sometimes authorization numbers are incorrect. Sometimes the service is incorrect on the denial notice. So if you know what you're asking for, say both of those things. That's one way to ensure that there isn't a mistake that happens on the receiving end. And so that's one way to make sure that the right thing is being appealed, and that you are getting exactly what you want. If you are given incorrect information by an insurance representative or by Medicare, document that information. I mean, you may not know what's incorrect at the time, but write down everything that's said to you. Because if you call and say, hey, look, I want to get a new kneecap, I want to have knee replacement surgery, and they say, yep, it'll be 100% covered. You go through all the process, everything's approved, and then your claim gets denied. Well, because they told you that they would cover it 100%, they'll do what's called a one-time exception because they provided incorrect information, and Medicare will hold them responsible for giving that wrong information. So it's very important to write down the date, time, and who you talk to, and what information that they give you. Most of these calls are recorded, and if not, there's notes about what the call was about and what the representative told you. Even if it's, I know everyone hears that this call may be recorded, but like 99% of calls are recorded specifically because of this. So these customer service reps often give wrong information, and people feel like, oh, well, they told me it would be covered, but now it's denied. They never think to bring up the fact that they called and got this information and told that it was going to be covered, and then miss the opportunity to have that reflected in their appeal and potentially get paid for what they've done. It's also important to communicate that to your provider as well. If you called and got the information, your provider provided services, and now they've appealed, It's important just to have a record of your interactions with these companies or with Medicare. That's one of the biggest things, that if they tell you something that's wrong, they have to follow through and approve the service or reimburse your claim. Document the date and time that you appeal. This is, like I said before, some of these appeals are down to the minute. And so if you know when you called, that is going to be the time that your appeal was received. There can be some issues with like the minutes on it, and it's still worth writing down what time you called and who you spoke to, and to have that readily available. I also recommend appealing more than one way. If you call, you should also fax, or most insurance companies, and I think even Medicare now has a portal where you can log in and submit it online. If you are not a tech savvy person, you can go down to FedEx or UPS, or have someone go and fax it to the company for you, or to Medicare for you. Mail is never the best way, because oftentimes it takes longer for them to process mail. It takes longer for them to get mail from you. And so it's just never really the best situation. If it's something like a claim, you can always send it in by mail. Most companies won't take verbal appeals for claims unless you have a disability that prevents you from sending something in another way. So fax is one of the best ways, or through the insurance portals. I know that's a little bit tricky for technology, but it's there. Hospitals and your doctor's office generally have fax machines too, and so they might be willing to do it for you there. So what are some proactive steps you can take when you're dealing with Medicare? Get your legal documents on file with your insurer. If that's Medicare, get it on file with Medicare. If it's Medicare Advantage, get it on file with whoever you have it through. It's important, not even if you are doing one of the power of attorneys or medical power of attorneys that only activate upon your inability to communicate. It's good to have on file then. It's good to have on file if you have one that's active now. If you have somebody that's under a guardianship, get it on file as soon as possible so that you can deal with all their insurance matters. If you don't want to do or don't have either of those three documents, you can fill out an AOR ahead of time and have it on file with your insurer. It's generally good up for the 1 year. And then if you need to send it in again, it can be renewed. You could just have one around as well before, if you're having surgeries and you know that there may be complications, to fill one out beforehand, so that if you are unconscious or unable to communicate, that documentation is already in place. Because once you're unable to communicate and you don't have these things on file, your care can be potentially delayed due to this. For no other reason other than it's protected information, and the right is totally with you. And so there must be proof, written documentation, that you've given this right to somebody else. If, let's say, you have somebody else appealing for you and there becomes like an issue, you have the right to revoke that authorization at any time, and then you can take over the appeal yourself. You can also let your insurer know that you don't want someone on your account anymore. Just because you filled the paperwork out once doesn't mean it lasts forever. You have the right to revoke at any point in time. So one of the best things you can always do is talk with your family or your supporters or your caregivers about what you want done in the event that you're denied care or that one of your claims is denied. I know we're talking a lot about pre-service stuff, but post-service is a huge issue too. I've talked with people who filed bankruptcy because they were paying claims that they should have appealed and gotten covered. It can be devastating to have a claim denied, especially with cancer care, with inpatient costs now going through the roof, and even with long-term care or skilled nursing becomes so expensive so fast and can wipe out savings in the blink of an eye. Final thoughts really is that no one can charge you to appeal on your behalf, not even an attorney if you hire them. They literally cannot charge you to appeal on your behalf. And that's why it's so important to exhaust all of your administrative options first, because after then is when you can, hire someone to continue your appeal in court. It's really not hard to appeal. A lot of people get intimidated by all the documentation and dealing with insurance, but you can literally just say, I want to appeal this, I need this care, and that's it. And then your appeal goes forward. The insurance is the one with the responsibility to prove that they've denied the care correctly. A lot of the times what we see is insurers will just deny your prior authorization because most people won't appeal. They'll just say, oh, I've been denied, I guess I can't get this, and they move on. But when you start the appeal process, you're asking for a higher level of scrutiny, and you're holding them to a different standard that can cost them millions of dollars if they do the wrong thing. Star ratings come out every year, and you can see what your insurance plan is rated with the star ratings through Medicare. Star ratings take everything through how they deal with providers to how they handle appeals. And you can look at every single insurer and see, okay, how does this insurer handle appeals? Are they untimely frequently? Are they unfair frequently? And that's public information that you can just get from the CMS website. I highly recommend it if you're thinking about an Advantage plan or you're thinking about dealing with Medicare, to look and see what the actual rates of these things are. I know Medicare Advantage holds a lot of benefits now because it covers more than traditional Medicare. So a lot of people are choosing to enter that market. And it's really important to see, how is this plan going to do if they deny me the care that I want or need? A lot of the times people are drawn to a certain plan because their provider is in network with them, or they have access to services through there. And so it's really important to see, okay, well, if I don't get approved for this, is it going to be timely? Am I likely to be hurt by their untimeliness? It's just another thing to consider when you're shopping for insurance. Also, complain, literally complain. I know I've heard stories about people being discharged from hospitals and shipped in Ubers to other places. Those people are on Medicare. Call and complain. They cannot do that. You're the only one that's going to complain about the treatment you're receiving. Your loved one is probably the only one that's going to complain about the treatment that you're receiving. For doctors do malpractice. It happens. Doctors treat patients not well, and you are the only one that can hold them accountable. If they're Medicare certified, if they deal with Medicare, or if it's Medicare insurance, Medicare will hold them accountable better than anyone else will. They hold the purse strings for these people, and so they can put the most leverage and weight on them. If there's a complaint and it's serious, they can even be fined for their actions and what they're doing. Medicare can initiate litigation about it. They can initiate a lot of things that are just not available to the everyday person, financially or otherwise. And so if you don't complain, nobody will know. And the people can continue on with violating your rights, providing you bad care, or taking advantage of you. So complain. It costs you nothing. All it takes is a phone call or filling out an online information, and that's it. Your loved ones can complain on your behalf. Some complaints require a legal form, but most of them don't. So I really wish that everyone would take more advantage of that, especially if it's a situation that doesn't seem right to you. I feel like, hey, this doesn't seem like something that they should be doing, or I really need this care. I don't see why it's being denied, or this information is wrong on here. They said call this number, but I called it and nobody answered, or it was a dead end or disconnected. Complain about that. That's a violation. Administrative rules are extensive and deep, and almost everything any insurer does for Medicare is based on those rules. So if they don't follow them, it's a violation. United Healthcare had a severe issue with letters and providing fax lines that didn't go anywhere. And so it wasn't until people started complaining that it was actually resolved and addressed and forced the company to do something. So your voice is the best voice to advocate for yourself. And Medicare does care because it's the government. And when they like to deal with these companies administering, they like to flex a little bit stronger on them. So finally, some important resources. Medicare.gov has all the information that I've just told you. They have the links to how do you file an appeal, how do you file a complaint, even on Medicare. And then to find your QIO, you can look at that link down there. QIOs will also care about things that you would complain to Medicare about. If you have traditional Medicare and you don't feel like your voice would be heard if you complain to Medicare, you can call your quality improvement organization and tell them what's going on, and they can file a complaint on your behalf and investigate it as well. Any problem that you have with Medicare or your Medicare Advantage plan, you can call and complain to the QIO or to Medicare. I highly suggest both of those things and that you become familiar with what's going on in your area, and familiarize yourself with the complaint process. You can look at examples of all these forms that we've talked about earlier, so that you might know what you're looking at when it comes time. And so it's really great information. CMS.gov is pretty easy to navigate. You can search it in the search bar there as well. And I think that's just about all that I have on my end. Are we going to open for questions?
Yeah, thank you, Melissa. That was excellent. Very informative, and I know I deal with this stuff quite a bit. Any questions, guys?
I have one. So what does KeyPro stand for again?
KeyPro is just the name of a quality improvement organization. KeyPro is one of two. The other is Levanta. Levanta deals with a lot of West Coast, like California area. KeyPro is the Idaho Quality Improvement Organization. It varies state by state. I don't think KeyPro actually stands for anything. It's just their big all caps best time thing. But they both, KeyPro and Levanta, have online appeals monitoring process. So you can now submit your appeal online to them and then watch it through the stages as the decision is being made. So they're very transparent in what they do.
I've got one for you. So during the appeal itself, if it is approved, will it be retroactive to the date, prior to the appeal for services provided?
So this is a really tricky area. Some cases, yes, and some cases, no. The some cases, yes, is generally to do with an admission. So like if you are admitted to a skilled nursing facility, that will be retroactive. So if you stay past the date, your last covered day during the appeals process, and your appeal is approved, it will backdate and cover it. If you choose to receive a service while you're appealing, you may have the appeal denied based on the fact that you received the service, and you will have to fight it in the claim side. If it's all possible, I would say don't. But in some circumstances, your life is literally in danger and there's nothing else that you can do. It's like either you wait the 72 hours or you die. And so if you're in that situation where it is that I need this now, otherwise I'm facing harm, you can always fight that on the back end of the claim side. And because you had a prior authorization going and an appeal going, sometimes it's easier to justify on the claim side why you didn't wait. But there's still a risk there in that.
Gotcha. Yeah, I mean, in my case, a lot of my clients are dealing with skilled nursing facilities looking for extensions, or rehab facilities looking for extensions, and they're typically getting ready to be booted, and every night is pretty costly.
Yes. So this, anytime they're admitted to something and it's the denial, the continuation of the stay, they will always be backdated. Confirm that on the phone though, too. Get that in writing, because even if they say, oh, it's not, if they've told you that it is on the phone, they have to cover it. That's why it's so, so important to write down, especially the date, time, and who you talked with and what they told you. If you ask us a specific question and say, look, I'm here, and they said, oh, I want to know, will this be retroactively covered if I continue to stay here? And they say, yeah, absolutely. And you turn around and the claim comes and they've denied it for those dates, you can say, hey, you told me that you would cover this, and there's no defense to that for them. They have to do a one-time exception. It was like one of the most common things, because the customer care representatives or whoever you're talking to on the phone, they have no idea. They are plugging in stuff, they are trying to pull up things, and they're getting basic information. And so when they tell you something, if the information is wrong, that's their fault. That's the insurance company's fault. It's not your fault. It's nothing you did, and you acted in reliance on that. So they cover it.
So I've got a question for you, Melissa. If a family is maybe starting this process or not sure if they should, are there organizations locally they can call and ask if their interpretation, if it makes sense to file an appeal, or should they call an attorney? What if they don't know what to do, and this class didn't answer all their questions, where do they go? Is it a KeyPro question? Is it a lawyer question? Where do they go?
It's definitely not a lawyer question, because lawyers, and I know I am one now, they have no idea what they're doing at this point in time. They're not medical providers. You can talk with your provider, I think would be the first thing that you would do. And, oh, sorry. Let me see, I'll make you more. Sorry, I'm making a host again. Make host. Change host, sorry. Talk with your doctor about whether or not this service is for you. Number one, it costs you $0 to appeal. It costs you nothing. And you don't have to do the service if you are approved, right? So if you are, the most common is you've been admitted to the hospital for some medical emergency. You're deciding if you want to go to an acute inpatient rehab, or if another facility is proper for you, or skilled nursing, and you want that, you apply for the higher level of care, being the inpatient rehab, and you're denied. Talk with your doctor, say, okay, is this really something that is good for me? If the doctor feels strongly that this is something that you should have access to, file the appeal. If the doctor says, well, you're not, it's kind of borderline, it's your personal choice then. Or if the doctor says, well, you're actually doing really good right now, I think that you can handle this other situation, you can always go and choose not to appeal. And then if in 10, 15 days, it turns out this isn't cutting it for you, you can appeal. You have generally 60 days. Your denial notice will tell you how much. Certification stuff for things like hospitals may be sooner, like 30 days. Just pay attention to like the end date of your appeal timeframe. After the appeal timeframe, you have to submit a new authorization request. That's why it's 60 days, because they feel like your medical information may change. The appeal process, so many people debate whether they should do it or not. I am personally an advocate of always doing it, because it literally costs you no money. It costs you no time. You generally don't have to submit any information yourself, because it's the insurer's job to collect that information from your provider. And so really you file your appeal and you kick back, you watch the time, and when the time's up, you either have an answer or you file a complaint. It's no more than a phone call or a fax or a portal entry on your time. And like I said, you can choose not to utilize the service if it turns out that's not what you want.
Thank you.
Okay, any other questions, guys?
Oh, I did forget something.
Okay.
For the post-service information, if your claim is denied, and it's because it's a Medicare non-covered service, most commonly an example would be like an eye exam. Medicare only covers eye exams for medical conditions like diabetic retinopathy or like cataract surgery. So if you go and you have your eye exam and it gets submitted to Medicare and Medicare denies the claim for not being a covered service, you can file an appeal. And if you didn't sign what's called an advance beneficiary notice, your appeal, they'll pay the service or the charges will be disallowed. Every time you're going to receive a service that isn't covered by Medicare, you should be getting the advance beneficiary notice or ABN. It should be completely filled out with the service, why it would be denied, and what the cost to you would be. And if you don't receive that information, there's a very good chance that you are not responsible for that charge. It is the doctor's and the provider's obligation to let the member know that this service will not be covered. If they don't do that, it is not your responsibility. This is in place to protect people from like fraud or from a bunch of excessive charges. The purpose is to let beneficiaries know that their insurance is not going to cover it in advance. A lot of people on Medicare are on limited incomes, and so it's meant to protect them from having these surprise charges before they receive this or after they receive a service. If you get an advanced beneficiary notice and you decide, oh, this cost is too much for me, then you can choose not to have the service, obviously, or at least you will know in advance how much it will cost you and you can work out an arrangement. I always would wait for the denial from Medicare before making a payment. If they say something, always have them run it through Medicare. I don't care if they say it's not going to be covered, have them bill it. Sometimes they will, sometimes they won't. And if they didn't do their part in providing you advance notice, then that's their problem and not yours. I know a lot of people, especially the older generation, get a bill and feel obligated to pay it right away, even if it, causes financial hardship. But with Medicare, it really is meant to protect the people from these exact situations. So it's always worth having things be billed, appealing if something is denied, and exercising your rights. It costs you nothing. It costs it can cost your pocketbook even less if you don't have to pay these things.
Perfect. Okay, any other questions, folks? Great. Thank you again, Melissa. And a huge thank you for McCool Law allowing you to provide this time. A big thank you to our sponsors, Peggy Farnworth CPA and the Counseling Center. All attendees will receive an email inviting them to join our mailing list. Just please confirm your subscription to receive the information for any free community education opportunities. Okay, and then please check your junk folder for the mailing list invitation. And then be on the lookout for our upcoming events. Again, you'll get the notification of when they are, and you'll have the opportunity to sign up. All right. Thanks again, folks. Hope this worked out for you. Thanks.